Hi everyone, I'm Khushi from LawWiser and welcome to LawWiser on Air. LawWiser is a legal community that brings together in-house leaders to engage in meaningful conversations around regulatory developments, judicial trends, and practical legal strategy. So today we are here to talk more about data localization, digital sovereignty, while also navigating through cross-border regulations and conflicts. To explore this, we have an excellent panel of experts with us. I'll invite our panelists to introduce themselves.
Hi, this is Jahnavi Upadhyay. I am part of legal fraternity for some time now. It's been 15 plus years. And my experience ranges from litigation to investigations, compliance, and advisory. Lovely to be here. Thank you for inviting me, Khushi. Thank you very much.
Hi everyone, my name is Akshayy Nanda. I'm a partner at Saraf and Partners. I head the competition law and the data privacy practice at Saraf. Thank you to Khushi for organizing this, and it's an absolute pleasure to do this discussion with Jahnavi and you.
Thank you for the introductions. So let's dive straight into the discussion now. So Janvi, the first question is for you. And, to set the context for our listeners, I'd like to begin with a broader picture. To begin with, how are you seeing this digital sovereignty translate from a policy concept into a real business decisions for global organizations?
So when you talk about digital sovereignty, it is an organization or nation's ability to control its own digital destiny. It encompasses control over digital infrastructure, data storage, software, and access rights. It ensures that digital operations, especially in the cloud, remain governable, secure, and compliant with local legal jurisdictions. It becomes actionable when leaders convert policy goals into concrete choices across governance, architecture, procurement, and operations. To start by mapping regulatory and risk constraints specific to vendor, data flow, and contract decisions. Then pilot a hybrid model that isolates high-risk data and services. For any Indian global organization, the priorities, they can look at priorities, data residency, access control, and vendor optionalization while balancing cost and innovation. A company's approach towards digital sovereignty can be by focusing on three main pillars, which is data residency, operational transparency, and technological autonomy.
So that's an interesting way to frame it, and especially when we are now seeing countries adopt a very different approach from to governing these cross-border data movements. So, Akshay, my next question is for you. India's DPDP Act adopts a very different approach to cross-border transfers. And how significant is this shift when contrasted with the adequacy-based architecture under the GDPR, and particularly in terms of legal certainty?
So thanks, Sushi. So under the DPDP, India has taken a very different approach in respect of cross-border transfer of personal data, as compared to the GDPR. So GDPR typically follows a whitelist approach, whereas India has chosen to follow a blacklist approach as far as transfer of data outside the country is concerned. So to give you an idea, so under the GDPR, personal data can be transferred to any country which has been formally recognized by the European Commission as offering essentially equivalent level of protection of data as that provided in the EU. So the European Commission, analyzes the data protection laws of other jurisdictions and does a thorough assessment, and based on that gives an adequacy decision that personal data can be transferred to these particular jurisdictions without any further authorization. So as far as transfer is concerned, in case there is an adequacy decision, personal data of individuals in the EU can be easily transferred to those jurisdictions. Now, in case a jurisdiction or a country does not have an adequacy decision, then the GDPR provides that you can rely on certain legally binding instruments, such as standard contractual clauses, which involve sort of certain sort of obligations plus carrying out a transfer impact assessment, as well as incorporation of additional security measures like encryption and pseudonymization. Uh, Apart from that, you can also rely on binding corporate rules, which are called BCRs. These BCRs govern is sort of a commitment that any transfer of personal data within a group, can be permissible even if the group entities are outside the EU. And these BCRs have to be approved by the supervising authority of the concerned member state, right? So this is typically the approach which is followed. Under the GDPR, there are certain derogations that in certain particular circumstances you can actually transfer personal data outside the EU, even though there's no adequacy, even though there's no SCC or BCRs. But these are very restricted sort of situations where, for example, it's for the purpose of performance of a contract, for the purpose of defending a legal claim. Um, Also, if you have the explicit consent of the data principal or the data subject, as they call it in the EU, um, and after duly establishing that the individual has been duly notified regarding the risks of such transfer, so there are these certain derogations as well. India, on the other hand, has taken a very different approach where there's no adequacy requirement under the law. The law says that you can freely transfer personal data to any country outside India, except to certain countries which will be blacklisted by the Indian government, right? So the government is going to, by notification, is going to come out with a list of countries to which personal data cannot be transferred. Now, the DPDPA Section 16 also provides that under different statutes, you can have higher restrictions and localization norms. For example, the RBI mandates that all payment-related data must be stored on servers in India. Under the insurance laws, the IRDAI mandates that all insurance records and other data must be stored on servers in India. So I think it's a very balanced approach which the Indian government has taken. Definitely, the Indian law is, comparatively compliance friendly as compared to the GDPR because you don't require such, thorough formal assessments before transferring any personal data outside the country. It's more commercially pragmatic and reduces the compliance burden on organizations, particularly organizations which are operating globally. But on the other hand, it does, raise a significant concern regarding predictability and legal certainty, right? Um, the GDPR, while it may be more complex heavy, more compliance driven, more process heavy, but it does provide a certain degree of predictability to businesses, because you have the adequacy decisions in place, and these are based on published standards and thorough regulatory assessment. On the other hand, in India, it's a policy-driven architecture. So this is sort of a quite a philosophical shift, from the legal standards approach under the GDPR to sort of a policy-driven architecture in India. So the question that organizations would ask is, when it comes to the DPDPA, which essentially should have been that what are the right tools that we need to put in place. Today, the question will be, as far as cross-border transfer is concerned, that what is the policy posture? When will the policy posture change and how quickly it can actually change, right? So therefore, it's important for organizations to keep informed regarding regulatory developments as well as, geopolitical considerations, because there's a large possibility that this cross-border transfer will actually, be determined by geopolitical consideration of the government, national security considerations, diplomatic relations. And in today's era, we see how these quickly change, right? So therefore, organizations need to keep in mind, keep abreast of whatever geopolitical changes are happening and how they will sort of affect international data flow. So yes, under the DPDP, it does provide more flexibility. It creates sort of a balance between ease of business, compliances by organizations, and also to protect personal data. It's not a case that any personal data can be freely transferred. There are provisions to ensure that sensitive data or is sort of localized and processed only on servers within the country.
So my next question is for you, Jahnavi. From the standpoint of companies, entering and expanding in India, India's DPDP Act attempts to balance regulatory oversight and ease of doing business. In practice, does this make India more attractive or more complex for global companies compared to the GDPR?
Thank you, Kushi. So, Kushi, India's DPDP Act makes India both more business friendly as well as complex at the same time. When you look at narrower scopes, pragmatic grounds of processing, etc., it makes it attractive. Whereas when it comes to new compliance categories, phased enforcement, India-specific transfer, and regulatory uncertainty to an extent, it makes it more complex. For India-based global organizations, DPDP lowers some operational frictions versus GDPR, and I think Akshayy really beautifully covered those things. India's act is generally seen as more simpler, more business friendly than EU's GDPR. If I put it in points, the compliance is streamlined, which means fewer lawful bases and simplified rights, reduce administrative overheads. Digital focus, if we talk about offline data handling, is completely out of scope, which lowers the obligations. The overall intent of this act is to be business friendly. The law explicitly aims to balance privacy with ease of doing business, unlike GDPR, which is rights heavy approach. India is one of the fastest growing digital economies, which makes compliance worthwhile for global firms. Whereas when it comes to the uncertainty, it makes it a bit complex, as there are rules which are still pending with for government notification. There is a higher child data threshold, like consent is required up to the age of 18, which is stricter than GDPR. There is an overlap of sectoral rules. So companies may face fragmented compliance until the harmonization which occurs, which will be quite phased. So these are the things which we need to take in consideration for global companies which are already GDPR compliant. India's DPDP is not automatically easier. It requires separate compliance strategies. In the short term, India's framework may feel lighter, but slight lack of detailed routes and reliance on government discretion can create regulatory unpredictability. So I think it's sort of a balance between the two, that yes, there are places where it is eased out. There are places where it can get a bit tricky.
And of course, that naturally raises a larger business question whether regulatory flexibility actually is simplifying operations or it's creating another layer of compliance interpretation, I would say. So, next question is for you, Akshayy. How should organizations navigate such situations where compliance with one jurisdiction's lawful access request could, expose them to liability under another jurisdiction's data protection framework? And how will we deal with this?
See, there is a real possibility of such conflicts coming up in the future, right? And when one jurisdiction demands that access to certain data, whereas that sort of an access may have repercussions under the data protection laws of another jurisdiction. Now, the fundamental problem why such conflict may arise is because the data protection laws and the government access laws are designed with sort of an aggressive territorial reach, right? And this sort of creates a legal dilemma for an organization. A government authority in one country is compelling access to the data, but this may have consequences as far as the data protection laws of another jurisdiction is concerned. So it creates sort of a legal dilemma what an organization is required to do. If you deny the request, then you can be subject to sanctions in one jurisdiction. If you grant access to the personal data, then that may sort of violate the data protection laws of another jurisdiction. So it's a very sort of legal dilemma, and there's no safe answer to this particular query. What organizations can consider doing, I think, a couple of things. One is they should thoroughly assess what is the request being made and what is the legal applicable framework. This should be done on a case by case basis. There needs to be a thorough assessment done by the organizations once they receive a request from the government, right? And essentially, what they should assess is that what is the authority of the government to raise such a request? What is the scope of the personal data which is being demanded? And then what are the compliance implications in the other jurisdiction where that personal data was collected and processed, right? Once that is done, then you should evaluate what are the domestic legal obligations and remedies. Is there a possibility where you can reach out to the government, and does the law provide a mechanism for challenging the request or sort of modifying the request, right? So that is something needs to be considered. Third, organizations can also consider implementing sort of some technical and organizational safeguards in order to sort of deal with these sort of conflicting situations. For example, if you're storing personal data, you can keep it in a encrypted format, and the key to the encrypted data can not be kept by you but given to the customer whose personal data you're retaining, right? So in that sort of a situation, even if you're required to give access to the data because the key is not available with you, the government will not be able to access that data because the key is with the customer in another jurisdiction. Uh, Furthermore, you can also sort of look at, choosing carefully the kind of providers and infrastructure service providers where, you have a certain sort of certainty that, the players in those particular jurisdictions cannot be compelled to, sort of share this data in case there's an access request by the government, right? Then, sort of certain other measures they can also consider is sort of having access controls like Jahnavi mentioned. Access control is critical that don't give access to everybody, right? Limit, which jurisdictional entities can access a particular data set. So this sort of then reduces the scope of what could be compelled from that particular entity, right? So there is no safe answer to that. There are these measures that organizations can consider. What is critically important is document everything. There needs to be a full audit trail of when the request was received, what the request was made, what is the action that the organization is taking, and I think all of this needs to be essentially documented. Um, right? So just to summarize, have a rigorous legal assessment process, find ways in which you can challenge the access request, see if you can modify the request, see how you can, sort of rely on pseudonymization of data in order to reduce the risks. And I think active engagement, with the authorities would be very critical.
That's really insightful, Akshay. And, I kind of think that these tensions would ultimately influence how companies are changing and making their entire technology and operational infrastructure as well. So, my next question is for you, Janvi. From a strategic implementation perspective, what are the top three practical strategic decisions companies need to get right when designing their data infrastructure across multiple jurisdictions?
Thank you, Kushi. The three most critical strategy decisions for a company designing global data infrastructure, according to me, would be where to store and process the data. Two, how to manage cross-border transfer under fragmented laws. And three would be which privacy enhancing technology, the PETs, and governance frameworks to be adopted. I think getting these right determines both compliance and competitiveness. So that's extremely crucial. Data localization and strategy, for that, you can take a decision probably whether to centralize the data in a fewer global hubs or maintain local storage in each jurisdiction. It is important because many countries like India, China, Brazil, they impose data localization laws as well for certain categories. Certain kind of data remains within the national borders. The centralized storage reduces, but then there are aspects also. Centralized storage reduces cost, but risk uh, um, of non-compliance enhances, whereas localized storage increases costs, but ensures global safety, regulatory safety. The best practice would be to adopt a hybrid model, global hubs for general data and local nodes for sensitive categories like health, care, financial, children's data that can be probably dealt with more sensitively. When it comes to cross-border data transfer mechanism, one has to look at how to legally move data across jurisdiction without conflicting rules. It matters because EU's GDPR requires adequacy decisions or safeguards, like standard contractual clauses and everything can be put in place. In India, DPDP 2023 will rely on government whitelists from permitted countries. Um, and so on and so forth. So best practice probably would be to implement something like interoperable framework, um, use contractual safeguards and technical measures like encryptions to reduce exposure, maintain a jurisdictional transfer matrix mapping which is good for legal requirements country by country. So these are things which can be implemented. When it comes to privacy enhancing technologies and governance. One has to take a decision as to which technical organization safeguard to be embedded in the infrastructure. It matters because the fragmented regulations make compliance costly. Your PETs like federated learning, um, etc., they are like, and decentralized identity can reduce risks. Um, Strong data governance frameworks like audit, role-based access, grievance redressal are essential for demonstrating accountability. The best practice would be to invest early in PETs to future-proof against stricter laws, align governance with global standards, and train international teams to ensure consistent compliance. I think training becomes extremely crucial here because um, we are in a very dynamic environment right now when it comes to the privacy laws. So it is better to keep your teams abreast. I think that is crucial.
So, thank you, Janvi. And now my next question is for Akshay. Given your competition law expertise, do data localization frameworks risk distorting market dynamics by, disproportionately burdening smaller players or new entrants?
Yes, Kushi, I think that is to some extent correct that, localization norms may have a significant impact on the ability of, smaller players and new entrants in the market in their ability to effectively compete with the large players in the market. Now, why localization frameworks are put in place, generally it's for, digital sovereignty, national security, and also from a personal data protection to ensure that during the transfer process, data is, not breached. But it also sort of has a tendency to restrict competition in the market, right? So I would say, like, if you have a situation where, there's an absolute localization framework as compared to the hybrid approach which Jahnavi talked about, which is the preferred approach, then what can actually happen is that this becomes sort of a compliance tax on the new players in the market, right? Which really would not be impactful on the large players already competing in the market, but on a new player, this would be sort of a compliance tax. Big companies today, they own data centers across the world. So if a law says that all data must be stored in India, so for them to just flip a switch on the server that they already own across the world, it's a very easy this thing. But for a new entrant in the market, this is going to be extremely challenging, right? So this is actually going to sort of increase the cost for a particular startup, where that cost sort of should be utilized for research and innovation and competing in the market. Largely that sort which has been raised to various funding rounds ends up going for storage spaces, right? So therefore, there is likelihood of a significant impact on new players. Like Jhanvi also mentioned that localization mandates can actually increase cost, significant cost if you require to locally store data. So this sort of prevents new players from actually leveraging, centralized, cost-effective, global cloud services which are available for them, right? Ultimately, this also has a significant impact on innovation as well as scalability. So, today in the AI era, so there's a lot of AI and data analytics which is being carried out, by literally every organization, right? Now they rely on massive data sets which involve cross-border transfer of personal data, and in order, sort of to train their algorithms more effectively. Now, if you restrict that ability on the cross-border transfer of personal data, then that would definitely have an impact on innovation as well as service quality. There can be also situations that today, if there is a particular player which does not provide, uh, cloud services in a particular jurisdiction, then the new entrants would have to rely on localized players. Where your challenge will be is it's going to be more expensive, and also possibility that it's going to be the other player, local player, may be less technically advanced, which then would raise risks under the DPDP, which mandate that there must be reasonable security safeguards to ensure that personal data is protected. Now, because of these increase in cost, that definitely would have an impact on competition, which is prevailing in the market, because these would not sort of impact the existing large tech players, but would definitely have a more impact on the new players and would be a significant impediment. Eventually, you look at a situation where it will lead to market consolidation, where there will be few players in the market. And as we know, the market consolidation may may ultimately reduce competition, reduce innovation, reduce risk-taking capacity in the future as well. So I think the government has taken the correct approach where they've sort of allowed free transfer of personal data outside the country, but have noted that under particular statutes you can have localization norms depending on the sensitivity of data, you know uh, importance from a national security perspective, etc. So I think that hybrid approach, which Janvi also mentioned, I think that is the correct approach, and that would ensure that new startups and new entrants in the market are not impacted by such higher cost of storage, as opposed to utilizing those funds for innovation, for competing effectively in the market against the large tech players, and for taking more risks as far as the businesses are concerned.
Thank you so much, Akshay. And that's a really crucial point, I would say. So, my next question is for Janvi. Looking at the bigger picture of business evolution, do you see evolving data regulations ultimately acting as a constraint on scale, or are they really pushing companies towards more resilient and innovative operating models?
So, Kushi, it might appear that evolving data regulations are constraining the scale for a company, but I think it is only for the short term. But they are also forcing the companies to build more resilient and innovative operating models in the long run. And as I said, it's a dynamic environment. What Akshay has also been explaining, it's a dynamic environment, right? So any organization, whether it is a startup or a larger organization, they already have systems in places, but all the organizations will have to become resilient and more innovative when it comes to their operating models in the long run. So this is actually helping the organizations, is how I see it. Um, the constraints would be that there is a fragmentation of rules. GDPR, India DPDP, China PIBL, and the US state laws are very different, making one size fits all infrastructure nearly impossible. Definitely, it is happening. Compliance costs are there, maintaining localized data centers. I think we both have been talking about the same thing, that the cost is major concern. So maintaining localized data centers, legal teams, and monitoring systems raises barriers to entry, especially for smaller firms. Cross-border frictions when it comes to restrictions on transfers flow down global integration, and limit the efficiency of centralized platforms. So these are the things which are sort of creating a constraints on scaling, but push towards resilience and innovation would cover your privacy by design and architecture. Companies are embedding compliance into infrastructure from the start, which reduces risk and build trust. When it comes to your PATs, which is privacy enhancing technologies, they are like um, tools like federated learning, differential privacy, and secure multi-party computation allow data use without exposing raw information. Modular infrastructure. Firms are designing systems that can adapt to different jurisdictions, especially plug and play compliances. Competitive differentiation. Strong privacy practices are becoming a selling point, especially in consumer facing industries where trust drives adoption. Um, when you look at the strategic outlook, in short term, regulations create constant scale by raising cost and complicating global operations. In the medium to long run, they push companies towards innovation, creating operating models that are more secure, flexible, and trusted. The companies that thrive will be those that treat compliance and not as a burden, but as a strategic capability, turning regulatory pressure into a driver for resilience and market advantage. So I think these are the things that's how I see.
Okay.
Thank you.
Thank you so much, Janvi. So, Akshay, next one's for you. Drawing your expertise advising multinational clients as well. So, from what are the most immediate on-ground challenges GDPR compliant organizations face when adapting to India's DPDP framework, and particularly, in cross-border data flows and operational restructuring, especially?
So I think first, I think it is important to understand that in India we've not reinvented the wheel. So the core fundamental principles of the GDPR and the DPDPA are pretty much the same, which is lawfulness and fairness and transparency of processing, purpose limitation, only use data for the purpose for which it is collected in the first place, data minimization, don't ask for more data than what is required, accuracy, storage limitation, don't store data for perpetuity, delete it once the purpose has been served, integrity and confidentiality and accountability. So the fundamental principles between India's law, the GDPR, Singapore's PDPA, the core principles are pretty much the same, right? Now, under the GDPR, what it provides is that for processing of personal data, there needs to be a lawful purpose. GDPR sort of provides six lawful bases to justify processing of personal data, which can be consent, performance of a contract, legitimate interest, legal obligation, public interest, and vital interest. Now, under the Indian law also states that, for processing any personal data, you need a lawful purpose, and the lawful purpose is either consent or certain legitimate uses which are provided under the Act. Now, the biggest challenge, I think, that multinational organizations who already complied with the personal data protection laws of other jurisdictions will face is that the lawful basis of performance of a contract or legitimate interest have not been included under the Indian law. Now, what is the implication of that? In the GDPR in EU, Singapore, other global jurisdictions. So organizations for majority of their activities, they rely on performance of a contract or legitimate interest. And for such processing activities, they don't need to take the consent of the individual because sort of consent is sort of implied. And the standard of consent is quite complex and challenging for every organization. So typically in EU, for sort of sending marketing messages, at most you need consent. For the others, you rely on performance of a contract, you rely on legitimate interest, and that serves the purpose. Now in India, we don't have performance of a contract or legitimate interest, so the lawful purpose is for processing personal data. So the challenge today in India will be is that for every activity where you process personal data, you can only do so if you have the consent of the individual, right? Without that, you cannot. So even for GDPR compliant companies where largely only for marketing they were taking consent, today they have to put that system, consent management system in place to ensure that for all the activities where they're processing data, they need to take the consent of the individual. So that is going to be a significant challenge for, all multinational organizations who are now attempting to comply with the DPDPA. Now, the other challenge will be is that consent requires that prior to seeking consent, you have to provide a privacy notice to all the individuals whose consent is being taken. Now, there are certain situations where you don't have a direct interface with the end user. I'll give you an example. Take the example of an online travel agency platform. Now, the OTA, it shares personal data with the hotels and the airlines, for the purpose of the booking, right? And the OTA has a direct interface with the end user. So the OTA shows the privacy notice, the OTA takes the consent of the end user, and then sends data to the airline or the hotel. Now, the airline and the hotel are separate data fiduciaries under the law or data controllers under the GDPR, right? Now the hotel, and they have to separately comply with their obligations under the law. Now the airline and the hotel don't have a direct interface with the end user, right? So how can they show a privacy notice to the end user? How can they take consent? How can they record that evidence of that consent being given? Now under the GDPR, because they rely on performance of a contract, that sort of a transfer and processing by the OTA and the airline and the hotel are legally justified. Now, this is one major problem which organizations in India will face because the law says that you're a separate data fiduciary, you have to take consent, and the organization will be like, but I have no direct interface with the end user. So how do I take consent? So that is going to be one fundamental challenge. The second, I feel, is going to be a major challenge is regarding notification of personal data breaches. So both the GDPR and the DPDP require that in case there's any personal data breach, then within a period of 72 hours, you're required to notify the individuals as well as the regulatory body, the data protection board here, and the relevant supervising authority in the relevant EU member state. Now, the GDPR provides some risk thresholds. So it provides that not every personal data breach needs to be notified. It provides a certain tiered risk threshold to say that in case there is the personal data breach is likely to cause any harm to the individual, uh, in case there's any risk of harm, then you're required to notify the authority within 72 hours. And then the second tier is if there's a possibility of a significant risk of harm to the individuals, then you're obligated to notify all the individuals whose personal data may have been compromised in that personal data breach. Now, under the DPDPA, there is no risk threshold. So even if there's a personal data breach is innocuous, there is no risk of harm. Under the DPDPA, you have to notify the board as well as all individuals within a period of 72 hours. In fact, the DPDP requires three set of notifications, one without delay to all individuals on becoming aware that there's been a personal data breach, second without delay a preliminary report to the board, and then followed up by a follow-up report with the board, within 72 hours providing additional details, right? And this is going to be the most challenging task for any organization, in particular in India. And also, I believe that because we don't have the risk threshold, then no matter every personal data breach, no matter the possibility of any harm to the individual, it creates sort of an obligation to notify the individual, the board. So that is going to be a major operational challenge for all organizations. Uh, Thirdly, I feel there's another challenge, for organizations, particularly significant data fiduciaries. So, unlike the GDPR, which categorize data, personal data as personal data and sensitive data, in India we sort of have taken a different approach, where rather than categorizing personal data, we have categorized the entity which processes personal data. So we have data fiduciaries, and then there are significant data fiduciaries, right? Now, significant data fiduciaries have certain additional obligations over and above the compliances which are set out, for all data fiduciaries under the Act. And one of the requirements is that on an annual basis, you're required to carry out a data protection impact assessment. And the this needs to be done on an annual basis for all processing activities, and the findings have to be then submitted with the data protection board. Now, the problem is that this is going to be challenging, and for organizations is, see, under the GDPR, even for data protection impact assessment, it's not done on an annual basis. There are certain criteria provided that, for example, if you're introducing new products and services, if you are carrying out a new sort of high risk processing. So, in certain particular situations, organizations are required to carry out a data protection impact assessment, right? Which obviously makes sense as well, right? But under the Indian law, there is no threshold provided. It merely says that on an annual basis, you carry out a data protection impact assessment. Now, today, every organization today uses personal data for numerous purposes, and carrying out a data protection impact assessment for each and every purpose on an annual basis, it really doesn't. I don't see the reason why having such a provision. It would have been better had there been a criteria provided that in case your processing falls under any of these activities, in case there's high risk processing, in case you start processing sensitive personal data, in case you're introducing new products and services, then in those particular situations there should have been requirement for a data protection impact assessment, right? So this is again something that I feel is going to be extremely challenging for organizations. So even if organizations are GDPR compliant, or it's not going to be a walk in the park. And lastly, I think another challenge is going to be, see, under the GDPR, you have the European Data Protection Board, which often provides these guidance notes on various issues. That how do you determine what is personal data? How do you assess whether you're a data controller or a data processor? Uh, in case of how do you assess whether analyze whether proceeding in legitimate interest? So for every activity, they have sort of a lot of these guidance notes which are issued by the European Data Protection Board, and that sort of gives certainty to people on what is it that they need to do, because essentially all these data protection regulations, they're more principle based legislations, rather than being very prescriptive. So under the Indian law, there's no mandate on the Data Protection Board to give guidance. So that sort of creates a challenge, because then you'll always have to ensure that what is the kind of complaints being filed with the board, what are the kind of orders coming out, what is the jurisprudence which is being established, and then that sort of puts a burden on our organizations to then continuously adapt accordingly to what are the orders coming out. And the challenge is today, if the board comes out with an order, you adapt, and then that order gets set aside on appeal, and you're like, now what do I do? Go back to the old situation. So I think there are going to be a lot of operational challenges for organizations. Um, when it comes to complying with the DPDP, even though it's simple, drafted in a much simpler manner, less restrictive, but I believe on the ground it's going to be more challenging than the GDPR.
Thank you so much, Akshay. So before we conclude, if there's anything further that you both would like to add or share or convey to our viewers, please feel free to do that.
Just a quick this thing. I'll just repeat. The DPDP rules were notified in November 2025, and all organizations have been given about 18 months to comply with the law. May 2027 is the deadline. I think 13th May yesterday I think it's just 1 year which has been left. 6 months are gone. So effectively, organizations have about just 1 year left. And also that, with compliance, it's a long process to comply with the DPDPA. There are a lot of requirements, and there are certain misconceptions that organizations have, such as that it's a one-time tick the box project, which it's not. It has to be a continuous endeavor as long as the business operates. Secondly, data privacy and data security are not the same thing. Data security is an integral aspect of data privacy, but just one of the many requirements under the Act, right? And thirdly, there's a lot which organizations need to do. And compliance with this law is not only limited to just reviewing and updating their privacy policy. So the clock is ticking and time is less, and there are lots that organizations need to do today.
So thank you both of you for your insightful perspective. So what clearly emerges from today's discussion is that data governance is no longer just a legal or a compliance issue. It is becoming more of a central to business strategy, operational resilience, and global market positioning. So thank you for joining us on LawWiser on Air, and we hope that we'll be able to do more such panels soon.